Current trans case brief. Case citation: Antonio and Ontario 1903626 2016 HRTO 560. Antonio became employed as a cashier with Mr. Constantinides' restaurant on September 4, 2014. She told Mr. Constantinides that she was 15 weeks pregnant at the time of her job interview, that she would be going on maternity leave at the end of December 2014. At the time of hiring, Mr. Constantinides was willing to provide accommodations for her pregnancy-related needs. However, he terminated her employment due to changes it made to the cashier's position. Although he relied upon the changes to the cashier position as a reason for firing the applicant, it also pointed to various other issues it had with the applicant in its response. The response states that the applicant would leave her post at the cash register to sit at one of the restaurant's table on a regular basis. The response states that the applicant was repeatedly asked to return to her designated work areas at the cash register to greet incoming patrons and answer the phone when it rang. She continually defied this instruction by sitting at the table in the restaurant. The applicant testified that she would often sit at the table in the restaurant because her feet were swollen due to her pregnancy. She said she was never aware that this was a problem. She testified that Mr. Constantinides never told her that it was an issue and had given her permission to sit down if she needed to when she was hired. She ultimately ended up filing a claim under the Employment Standards Act for overtime pay, vacation pay, and unauthorized deductions. She also claimed that Mr. Constantinides reprised against her within the meaning of the Employment Standards Act. An Employment Standards officer upheld the applicant's claim in part. However, he denied her reprisal claim on the basis that she had failed to confirm how she was reprised against and for which specific protected activity. In terms of this case, the issue needed to be solved is, did Mr. Constantinides violate the right to equal treatment with respect to employment without discrimination because of sex under Section 5 of the Code, which includes the right to equal treatment without discrimination because a woman is or may become pregnant? The application of this case is dismissed. The judge carefully considered whether the applicant's pregnancy, her upcoming pregnancy leave, or her request for pregnancy-related accommodation were factors in the termination of her employment. The judge finds it unlikely that the applicant was terminated either because of the fact that she was pregnant or because she would be taking pregnancy leave as of the end of December 2014. It was not disputed that Mr. Constantinides was aware of both of these facts when he hired the applicant in early September 2014. Therefore, the judge does not find it likely that they were factors in his decision to terminate her employment less than 2 months later. The judge then turns to whether the applicant's pregnancy-related accommodation requests were a factor in the termination of her employment. It is important to note that, under the Code, a respondent has a duty to accommodate an applicant's pregnancy-related needs up to the point of undue hardship. It was not disputed that the respondent had complied with the applicant's only accommodation request, which was to be able to sit when necessary. The applicant agreed that Mr. Constantinides had never spoken to her about her need to sit down, and that he had never told her not to sit down during her shift. This evidence supports the respondent's claim that the applicant's accommodation requests were not a factor in the termination of her employment. The judge finds that the applicant has not met her onus of proving that it is more likely than not that her pregnancy was a factor in the respondent's decision to terminate her employment. In some cases, the tribunal has dismissed applications on the basis that an Employment Standards Officer (ESO's) decision under these provisions has appropriately dealt with the substance of the application. However, the Employment Standards Act (ESA) proceeding in this case did not appropriately deal with the substance of the application. The applicant's claim under the ESA included a claim of reprisal under the ESA. The ESO commented that some of the surrounding facts found during his investigation suggested that the applicant was not reprised against because she was planning on going on maternity. However, his decision was ultimately based on the applicant's failure to provide evidence to satisfy him that he was exercising one of the protected rights under the ESA. He also did not appear to consider whether the applicant's pregnancy and accommodation needs were a factor in the termination. On this basis, the proceeding before the ESO did not appropriately address the substance of the application before this tribunal. The survey question is, was the decision of the tribunal to dismiss the application an appropriate one?